The evil insurance companies got their way in Louisiana, and now there's tort reform that just came through. The governor signed off on some bills, and we're going to talk about one of the biggest changes to Louisiana law having to do with comparative fault and who is at fault and how that can bar your recovery as a plaintiff, and that's what we're going to be talking about today. Louisiana just passed a law that starts on January 1st, 2026, that if the plaintiff, the person filing a lawsuit, is found to be 51% or greater at fault, they get nothing, zero. Okay, let me explain to you the way the law used to work. It was a pure comparative fault state. And so anytime you bring any defendant, now look, you have to have good grounds to bring any defendant. So we're not just pulling people off the street. You have to survive summary judgment and have good grounds to bring a defendant forward to trial. But any defendant could be allocated some fault. Maybe they have zero fault. Maybe the plaintiff was 100% at fault, and everywhere in between. So even if you just found a defendant 1% at fault, 10% at fault, they still have to pay something to the poor plaintiff that was hurt. Let me give you an example. In the case of an 18-wheeler case, all right, so there may be the logistics company, the dispatch company, the hauler, the driver, the load was improperly loaded. You can bring all these different defendants. And if they survive to get to a trial, the jury could say, you know what, we think that the dispatch was running that trucker too much, and so we're going to allocate him 10% at fault. We think the trucker was 60% at fault. You know, the plaintiff had some fault because they were speeding, so we can apply 20 or 30% to the plaintiff. You take the full sum of what the jury awards, let's say $1 million, and then you break it up percentage-wise. And if the plaintiff has 30% at fault, well, they can't recover $300,000 because they were at fault. The rest of the $700,000 would be distributed by the defendants according to the fault allocation that a jury of their peers set. Now it's different. So what changed? So the new law is a modified comparative law, which bars the plaintiff from recovering anything if the plaintiff is allocated 51% of the fault or better. And so if the defendants prove that the plaintiff was just a little bit more than halfway at fault, they can't recover anything. And so in the old scenario, in the old law, they could still recover 49% if they were found 51% at fault. Now they can't recover anything. So it's a huge change. And so I'm going to give 3 cases of examples where I think that this is going to affect our ability to represent people. And we may not take those cases after January 1st, given the new changes in the law. Let me give you an example of a case that used to be a good case with comparative fault, but now we probably won't take the case with the new law. Your classic 4-way stop. Okay, and so you have a stop sign, a stop sign, a stop sign, a stop sign. Everyone has to come to the intersection and stop. Well, sometimes 2 cars go at the same time and collide here in the middle. All right, the car that is further through the intersection is the better case because they probably started first. And don't forget, the car on the right has the right of way if 2 cars come to the stop at a 4-way stop at the same time. That case used to be a good case with comparative fault because best case scenario, we put 100% on the other driver. Worst case scenario, we get 50% on the other driver. Now, if it's a closer call and we're found 51% at fault, we get nothing. And so you used to get something. Now you get nothing. So those cases in 4-way stops, where it's a he said, she said, and both enter the intersection at the same time, those cases are not going to be taken by attorneys because the risk of 0 is real. Let me give you another example. You got a 2-lane highway, 1 car going this way, 1 car coming this way, the opposite side. Well, did you know that if you're overtaking a vehicle, you can go around them, even if they're taking a left? Now, if you're taking a left into a private drive, you have to yield to this on-taking car. If you're taking a left into another highway, you do not have to yield. this car, the overtaking vehicle, has to yield to you. That's a closer call. Those cases are always fact dependent on who should have yielded to who, because we know that you have a high duty when you're taking a left, but how many people are checking their rearview mirror on a 2-lane highway to see if someone is overtaking them when they're taking a left? When did you put your signal light on? Should the overtaking vehicle know that you couldn't see? It's a closer call. Those cases, worst case scenario, we could still get 50% in the old law. Now it's a closer call. If the defendant can show that we were 51% at fault, you get nothing. It's too risky to take these types of cases now. Another type of case that I think is going to be drastically reduced is the slip and fall case. So you're at Walmart, the roof is leaking, there's water on the ground, there's no wet floor signs, it's a mess. Slip and fall cases are hard enough as it is because you have to prove that they knew or should have known of the hazard, and that has to do with the time period that the hazard was on the ground. You have to have witnesses or camera footage. It's a tough case to begin with. Well, if the defendant can start poking holes in what you saw or should have seen, and whether you were wearing flip-flops and what kind of footwear you were having, or what was your gait like, or what were you doing, what did you have in your hand at the time, and all that stuff. If they can start poking holes in an already difficult case and get you to 51%, you get nothing. So it used to be, if you could prove that Walmart or any of the retailers were 10% at fault, 25% at fault, 30% at fault, you can still get a recovery and get something for your client. Now it's too close. If it's not a slam dunk, those cases will not be taken under the new law. One of the risks is that the juries know about that 51% bar, and so they'll see that object and kind of steer to it. And so they know the defendant did something wrong, but maybe they don't like the plaintiff and they don't want them to recover. So they can still allocate 49% at fault to the defendant, which they know did something wrong, but they don't like the plaintiff, so they'll award 51%. And so that seems unfair, but it helps the jury sleep at night knowing that they've said, yeah, they did something at fault, but we didn't like the plaintiff. So in tough jurisdictions with stingy juries, they're going to give a tie. And in a case where there's still a tie, the plaintiff could still lose at just 51%. It's not like baseball where the tie goes to the runner. It's not going to work that way. In that situation, the plaintiff will get nothing. So now that you know that the law has changed, what can you do if you're involved in a wreck? Well, you need to get witness statements as soon as possible. You should be driving around with a dash cam. You need to locate any cameras that may catch the wreck. You need to get a thorough statement. I just had a case this week where my client, I knew he was right, but he wrote a poor statement to the police that he didn't say his light was green. And so now it's a 50-50 case. It's a he said, she said, and then he had to go back and change his statement. That just looks bad. We need to get that information as soon as possible. Get with a lawyer to help build that case. Now that the game has changed with the new law, it's important more than ever to get as much information as possible, as early as possible. If you found this video helpful, please check out our other video, whether to settle or to sue, and be on the lookout for our next upcoming video talking about other changes in the Louisiana law, specifically no pay, no play, and why you should always have insurance on your vehicle.